Good afternoon. The Metro Board of Zoning Appeals in session for the rescheduled meeting, 17th, 22. I'm Elizabeth, presenting the cases that are on public today before the board. This time, I would ask everyone please turn off or silent phones. Procedures for matters on public hearing today will be to present site plans, photographs, and maps of the subject properties. Letters we've received in support or opposition, as well as correspondence from other government agencies, are maintained as part of the case record and have been provided to the board members for review. At the conclusion of the staff's presentation, the appellant will have an opportunity to present their case to the board, as well as anyone who is present in support of the application. If there is opposition to a case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have an opportunity to rebut the opposition testimony. Pursuant to our board rules, an appellant who does not have opposition present will have 5 minutes to present their case. In a contested case, the board provides 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 10 minutes. All section numbers that we refer to today come directly from the Metropolitan Zoning Code as adopted by the Metro Council. These proceedings are recorded, so it's imperative that anyone addressing the board speak into the microphone, identify yourself, and provide your address, and then make your presentation. Please be advised that providing false or misleading testimony to the board may result in the revocation of your permit after a show cause hearing. The board will go through all cases set for public hearing today. After each case, the board will discuss and vote on that case. The Metropolitan Zoning Code requires 4 affirmative votes to grant your application. In the event there are not four affirmative votes, the application will be reset to the next meeting. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be denied by operational law. The appellant or other interested party may request a rehearing within 60 days. Parties may also appeal the board's decision to the Davidson County Chancery Court by filing a writ of certiorari within 60 days. All parties are encouraged to seek independent legal counsel regarding the filing of an appeal to ensure that all deadlines and procedures are followed. If you're an appellant and your case is granted, it will then be necessary to obtain the permit for which you've applied. Please note that the permit must be obtained no more than 2 years after this board's approval. There are a few preliminary announcements that we would like to make at this time. On the board's docket on page 2, case number 2022-28 has been withdrawn. If there are any members of the public here to speak on that matter, which was a request for a rear setback variance at various properties on 17th Avenue South, that matter has been withdrawn by the appellant. If there are no other matters on which you wish to be heard, you are free to leave, or you may also stay, as this is a public meeting, but that item is no longer being requested by the appellant at this time. On page 3 of the board's agenda, case numbers 2022-30 and 2022-31B have both been deferred to the next meeting on April 7th. That meeting, we would note, is at the Metro M&PS School Board on Bransford Avenue. Sorry? Oh. That's right, isn't it, Joey? Okay, thank you. Let's see, the board has, okay, if there are no other preliminary matters from members of the board, then we'll move on to the consent agenda. The board staff has a consent agenda that we were proposed for today. A board member reviews the record in each case proposed prior to the hearing, and if in their opinion the applicant meets the criteria for the application requested and they feel testimony in the case would not alter the material facts, the case is recommended to the board for approval. We will call the consent agenda for cases that have been recommended for approval, and if there's anyone opposed to one of these cases, please raise your hand and the case will be removed from the consent agenda and heard in its regular order. The items recommended for today's consent agenda are case number 2022-29 on page 3. Case 2029 is a request for a special exception for property located 1805 Church Street in the MUIA zoning district. The applicant is seeking to amend the special exception to reflect a permitted height of 16 stories. Is there anyone here in opposition to case number 2022-29? Okay, seeing none, this item will be recommended for approval on consent. The other item on consent, or recommended for consent today, is on the last page. Case number 2022-34. This is a request for a street setback variance for property located at 1268 Cheyenne Boulevard in Madison in the R10 zoning district. Is there anyone here in opposition to case number 2022-34? Seeing none, this matter is also recommended for approval, and at this time we would ask the board to submit a motion to adopt the consent agenda.
Motion to adopt.
Second. All in favor of the motion to approve the consent agenda, I'll eventually figure that out. All in favor of the consent agenda motion, say aye.
Aye.
Any opposed? Okay, that passes.
Thank you. For appellants whose items were just approved on consent, you're free to go. Please give our staff a few days to process the documentation associated with your matter today, and then you may come into our office and pursue the permits for which you've applied. I don't see any council members present, Mr. Chair. So at this time, we will move on to the matters in the regular order on the docket for today. The first matter before the board is case number 2020-118. This is a rehearing of an item A appeal challenging the zoning administrator's decision to revoke a permit pertaining to a billboard. This matter has been on the board's agenda for several times, and so I will submit for the zoning administrator to make a presentation.
Mr. Chairman, members of the board, thank you. Joey Hargis, Metro Zoning Administrator. Members, I come before you to correct the record, which I stated at the public hearing on March 3rd. I had made a statement after the board's vote, which I'll cover in just a minute, that this case would be reset and re-advertised for a new public hearing. That is incorrect. After reviewing the tape and the footage of the hearing and looking at section 240 of the Metro Code of Law, as well as 9C of your rules, the vote went down as follows, and I've entered a corrected order and provided both the appellant and you all a copy of it. But the vote went down as such. The motion was to overturn the zoning administrator, and those members voting in favor, Ms. Carpenek, Mr. Newton, and Mr. Pepper. Mr. Lawless has voted against the motion. Ms. Davis abstained or did not vote in the case, and Mr. Cole was ineligible because he had not participated in the case. Ms. Davis's inaction, or effectively an abstaining vote, is a fifth member participating in the case. So you had Ms. Carpenek, Mr. Newton, Mr. Pepper, Mr. Lawless, and Ms. Davis participated in the case, and under your rules and 1740-240, failure to achieve 5 votes in that case, this motion stays on, and that's why it's on today's agenda for the next 30 days. There's only this meeting within that 30-day window. So this case is tied up on votes with the motion to overturn the zoning administrator. With that, I entered an amended order to the case, provided the appellant a copy of that, and that's where we stand at this time. So
Your zoning administrator's position today is it's up for rehearing today.
It is not up for rehearing. This is a rehearing from a 2020 case, but this case is, remember the first motion from September, I keep saying that, from February the 3rd was a motion to uphold me and uphold the revocation of the permit. And the votes in that case, there were 3 in favor, 3 opposed, and Mr. Cole was absent. So the original motion was to uphold the zoning administrator. That motion was tied on votes. On the 17th of February, we reopened the public hearing to allow the sports authorities letter that they had sent in to take testimony on that, and you all voted to reopen testimony, so that was then set for March 3rd.
So we're still at the that's still considered the first hearing when we reopened it, correct?
It is, yes, sir.
Okay, so, all right, I'm with you.
So the motion we had originally on the table was to uphold the zoning administrator. That motion failed, and it failed when you, Mr. Pepper, changed your vote to go from affirming the motion to uphold the zoning administrator to overturn the zoning administrator. So that vote in that motion was 2 in favor, 4 against, in that case, so.
And so that's how we ended the first hearing, essentially?
It is. That's how we ended
Making this the second hearing, okay.
Yeah, that's actually how we ended the second hearing, because you voted to change your vote at the second hearing, but also agreed to reopen to allow the sports authority's testimony in, and to give Mr. Henry the opportunity at the next meeting to rebut any testimony that they put on. So, and those 2 meetings were in the original
Right.
30 days.
Yeah,
of the first
so,
action.
and I did agree to reopen the hearing, but that was after, it was either you or Chairman Taylor said that the proper procedure at that point was to reopen the hearing.
Correct.
So,
Correct. So then, on March 3rd, we took the testimony of the Sports Authority. Mr. Henry, no one from the Sports Authority appeared. I spoke, again, restating that the permit should be revoked. Mr. Henry testified during his rebuttal period and put on his case in chief there. A new motion came forward on the floor then, and the motion was to overturn the zoning administrator with the votes as spelled out before. So the motion on the floor now is to overturn the zoning administrator's revocation. We have 3 votes in favor, 1 vote opposed, 1 abstention, and 1 member absent. So we're getting our 30-day clock reset on March 3. So this meeting is within that 30-day window. We do not have another regularly scheduled meeting before the 30 days elapses. So I've entered an appropriate order.
right. And so, and I know Mr. Henry submitted a letter. Here was my concern that and let me ask you about it, and then we can address it with the board. Well, I thought that if we go back to the original hearing, if my vote is reversed, then what would have naturally followed would have been a vote to overturn the zoning administrator, and there would have been 4 votes for that because there were 3 votes against the motion to uphold you. So what I am struggling with is, and I deferred, it was either to you or Chairman Taylor about what happened at the last meeting, and it may have been correct, and it's something we're going to have to discuss as a board, but when I started thinking this through and the kind of procedural situation we're in is that when I reversed my vote, at that point, is for all practicality, there were 4 votes there had not been a motion made, I understand, but for all practical purposes, there were 4 votes to reverse the zoning administrator. And so, what is the zoning, what is your position on that? So, because I think we need to have a discussion about
Sure.
that.
My position on that, one of those 4 votes is Mr. Taylor's vote. And Mr. Taylor's term expired after that first motion. So the date in which you changed your vote was Mr. Taylor's final meeting, if I recall the timeline.
But he was here. He
Right,
was here when I changed my vote.
Right, he was present, and that was his very last meeting.
Right.
In that, I think what you're saying is there should have been immediately a subsequent motion in the inverse to.
Right,
to
yeah, I mean,
overturn.
that's what I'm,
And
there
that,
were 4, the applicant would have had 4 votes at that time to overturn the decision of the zoning administrator. And so, procedurally, I remember, I thought when I reversed my vote that the next thing, that would just happen automatically. But, so it was either you or Chairman Taylor said procedurally we have to do, reopen the hearing, I think, so.
right, it was, I think, coupled with the Sports Authority's submission to this board for you to consider it part of the record. We'd had to open the public hearing, give the appellant opposition to rebut that testimony.
But I think we had to vote to reopen the hearing.
Yes, you did.
Okay.
You did.
It was, they didn't have by right, they couldn't just come in and reopen it.
Correct.
Hearing, okay.
Correct. And that was the 217 meeting. And at 217, because that letter came in effectively late, Mr. Henry in fairness to him, would have no opportunity to prepare to rebut it, which is why we allowed that to happen on 3-3. But to your point, the 217 meeting, with the changing of the vote at the prior one, should have been a subsequent, the motion currently on the table to overturn the zoning administrator. But I guess where we fall in that, Mr. Taylor wouldn't have participated, because he didn't participate, we're sort of in this limbo now that there's, his vote and his participation in the case is, I guess, nullified by he's no longer on this board. But I think to your point, at the 217, or when you changed your vote, there should have been a subsequent motion in the opposing direction.
Well, I mean, that's for the rest of the board to decide. I think that I've never run into this procedural situation. You may not have either. I mean, I think we just have to have a discussion about that.
And also, I guess, leave it to your legal counsel to give you advice upon that.
Sure, of course.
I'm not. I'm a lawyer. I'm not serving as your lawyer, unfortunately.
Well, I mean, I guess, I understand, and Mr. Henry submitted a letter asking us to waive the zoning code, which we can't do, but back to the, so is your position that because Mr. Taylor is no longer here, then the 4 votes?
I don't think there's a way to undo that, given the current membership of this board. If Mr. Taylor had continued to serve in this capacity, then I think that opportunity could have availed itself. But I don't think there's any way to go back in time and fix that with the opposing motion. You do have the opposing motion currently on the floor, but to your point, I don't know a way to remedy that. Now, given
so your position would be it's not, we didn't do anything procedurally improper last time, therefore we can't say that if things were done procedurally improperly last time, the applicant would have had the 4 votes. That would be your position.
Correct. I don't know that standing here, there's a way to correct that. Now, certainly if whichever party wishes to appeal, a chancellor can certainly fix that, should they see fit. But I don't know of a way to remedy that without Mr. Taylor being present and participating in this case. So procedurally, I mean, we're at where we are with a second, a new motion, which is to overturn the zoning administrator, but that motion is also now tied up on votes from a vote of 3-1, 3-4, 1 against, 1 abstaining, and 1 not participating.
Okay.
That's kind of where I'm at with this. So with that, where we are, again, as I have in previous testimonies, I'll start first with Mr. Cole. Mr. Cole, have you watched the proceedings of the prior hearings in this case?
I have not watched all of them.
Okay. With that, Mr. Cole is not eligible to participate. So we're back to the 5 members who present who have participated. Again, the motion on the floor is to overturn the zoning administrator. The current votes are Ms. Carpenet, Mr. Newton, Mr. Pepper, wishing to overturn the zoning administrator. I'll poll you 3 first. Do you wish to change your vote this time? None. Record reflects no changes there.
No one wish to change their vote?
No.
Is that correct? Okay.
I'll then turn to Mr. Lawless. You voted against the motion. Do you wish to change your vote in this case?
I do not.
Okay. And Ms. Davis, are you continuing to abstain on this case?
I am.
Okay. With that, by operation of law, this case has failed for a failure to obtain 4 affirmative votes within 30 days of its hearing, and an appropriate order will be entered and provided to all parties. So that case 2020-118, the applicant's request has failed, and the zoning administrator's determination that the sign must be removed stands. So we'll move to our next case, Ms. Waits.
Okay, so now we're at 2 meetings and they failed at 2 meetings. So I still think your position is that they never got 4 votes, even though I changed my vote, so, correct? I mean, do you agree with your input for us as the board to get procedurally? I don't, in my opinion, we can't the zoning code, but to proceed issue is the risk, and everybody may have an opinion about it. Is that something you feel like you can go on and decide? That
In my own opinion, I don't think that situation without Mr. Taylor participating.
But what is the next step for this applicant?
The next step for this applicant, we will not have a hearing within 30 days of March 3. Between our next hearing is April 7th. Yeah. So there's not a second opportunity, so the motion that's tied up on votes will fail by operation of law before, at the 30th.
Are they allowed to apply again, new case number, sometime in the future?
They've got 60 days to appeal this board's action. The procedural process typically deny, this is not a variance. The code points out variance request and refile after 6 months, but this is not a variance request. This is an administrative appeal. So I don't know that there's an ability to do that. As Law said, I think their appeal now is to the judicial. He's going to come by and reset our mic, of course. Fluff. I'll take responsibility for that here at the podium. Thank you.
Double have to, maybe not.
All usually
May have to on and off.
Okay. We're going to have to take a brief recess. 5 minutes while we reboot the entire system.
so we're having technical difficulties. We'll take a brief 5 minutes or something. That's now. So we'll adjourn for 5 minutes. This. Yeah.
Mr. Chairman, the next case on our agenda is case number 2022-19, which is an item A appeal challenging the zoning administrator's determination that properties located at 3982 and 3978 Taylor Road are not duplex eligible. Is there anyone here on case number 2022-19? Mr. Chairman, no one's present at this time. May we please put this item to the heel of the docket?
Okay, have you heard from Mr. Bain? Has he said he's going to be late or anything like that? Okay. We continued this last time, right? Because he wasn't here, as I recall.
He actually did send a deferral request on that one.
Okay, he did. Okay. All right. Okay, so we'll put that to the heels.
Thank you. The next item on the agenda is case 2022-26, which is a request for variance from a sidewalk requirement for properties located at 2600 and 2602 Pennington Avenue in the R6 zoning district. The appellant is seeking permission to pay the sidewalk in lieu of construction, the sidewalk fee, Planning staff review all sidewalk waiver applications and recommended a waiver of the sidewalk and to permit the in lieu fee along Pennington Avenue. This is a corner lot, but requested that a sidewalk be built to standards along Cahal Avenue. And then I will pull up the presentation on this matter. Before you is the zoning map of this property, aerial photography to get a sense of the surrounding properties. This is the site plan submitted by the applicant, and this is a photograph of the lot as it exists today. And there's one more photograph of the lot. Is there anyone in opposition to this matter? Seeing none, Mr. Chairman, the applicant's representative will have 5 minutes to submit a presentation.
Thank you, Madam Secretary. Thank you, Mr. Chairman, for hearing our case today with regard to the property at 2600 Pennington. My name is John Michael, Thompson Burton Law Firm, 1801 West End Avenue here in Nashville. The request before you is a request for a modification from the legal requirements associated with sidewalk construction for the two-family construction project at 2600 and 2602 Pennington. I'm careful to phrase it that way because this is not what we used to disdainfully refer to as one of the old Bob Marley cases, where somebody, instead of wanting no woman, no cry, asks for a no build, no pay scenario on their sidewalks. Those folks are greedy, and you should call them out on it, as I do when they call me and make those requests. Here, the sidewalk waiver process yielded an answer of no construction, no payment on the long side with Pennington. I think your aerial will give you a sense of that 230 some odd linear feet. There we go. Even the survey would suffice, but you get a sense of how long that is. The 237 feet, I think it is. They said no build, no pay, specifically because of the carefully maintained ditch at that location, which, given the topographic conditions coming from Cahal down Pennington, is an important piece of stormwater management. Stormwater gave feedback on the waiver process that they did not want to see any construction there that would harm their stormwater management tool that is in place at that location. However, the waiver process did say that we were required to build out the updated and improved sidewalk, the 5-foot sidewalk and 4-foot planter strip, on the 56-foot frontage on Cahal, which you see in the photograph to your right there. The request that we're making today is for additional relief even beyond that which was previously granted through the waiver process. And the rationale, going to the hardship, is the topography up at Cahal. I think if you go back, if I may request that that photograph is a great way to show it, and then the second one helps as well. There is a drop-off from Cahal down into the subject property, which creates a lot of the water flow that ultimately comes into this ditch line and downstream as we go beyond these properties and onto neighboring properties down Pennington. Although the stormwater problems are not made horribly worse by construction of the sidewalk, at least not necessarily, because engineering requirements would mean that this would be constructed in a way to help manage that stormwater runoff. The reality remains that the engineering of whether it be retaining wall or some other engineered structure to help hold up a 5-foot sidewalk separate from the 4-foot planter strip goes deeper into the property, and it is the engineering of that finished sidewalk product that would create even greater stormwater complications because of the topography. So what we're asking then is for permission from the board to grant a variance that would allow us to make the payment for the 56 feet along Cahal to the sidewalk fund as contemplated and allowed by law, and then just fix up the existing 4-foot sidewalk that's in place because it is an older one. It is in need of some upgrades. We recognize that, and my client is quick to say they're eager to do that. I want to note here that we've been in persistent conversation with the council member, Emily Benedict, who does great work in this district, and besides being a professional colleague, I consider a friend as well. So although she is not here today, and to my knowledge, Joey or Elizabeth, please correct me if I'm wrong, has not submitted a formal letter or email with regard to this project, we've talked about it quite a bit. So what I think is very important to say is she prefers the updated sidewalk along Cahal, the 5-foot and 4-foot. So I'm saying that
if I may
against...
respond. Yes, she did submit an email to the board, and it's before the board.
And what was the date on that, if we may ask?
I'll pull that up, and I'll be happy to read it out, if you would like.
Mainly just the date.
I'll find that.
So while Ms. Waits is looking for that, I want to just represent that she does want that. We understand. She recognizes the engineering challenges and the stormwater problems associated with the property. And the more she and I went back and forth about it, we never really got to the bottom of I strongly oppose, I strongly support, because after she originally opposed, we talked a lot more about it. She drove the site again, very much to her credit, going out of her way to go by here. And we just kind of left it at that. So the request that I'm making is for permission from my client to just make payment on the Cahal side, the 56 linear feet at whatever the going rate is as established by NDOT. In the alternative, and if the board is not inclined to buy that request, my client has authorized me to say, we recognize that there is need for upgrades in the sidewalk infrastructure in this part of District 7 in particular. We would be willing to pay into the in lieu fund as contemplated by law for the entire property. Now, we benefit there from the 3% cap as outlined in the ordinance at 17.20.120, which talks about how there's a 3% cap calculating back from the building permit's cost of construction. Here, I think that was maybe $350,000. So you're talking about, instead of a small contribution, a substantially larger contribution to the sidewalk fund. If that larger contribution is something that the board would find an appropriate solution, it gets us out of construction of the sidewalk itself. And here's the big why. If we have to build that updated sidewalk, it's necessarily going to trigger a grading permit from Metro Stormwater. The going timeline on those is 7 or 8 months. The design professionals on the board know exactly what that does to a project. They know that that timeline is not flexible. There's not some fancy lawyer that you can pay entirely too much per hour to go push them along. Questions have been asked to that effect. But no, it takes as long as it takes with that engineering study. And the prerequisite in that study is likely to be a spread study to determine how the water would respond to that construction. The cost is one thing, but honestly, it's not very important to my client today or other clients that I represent. It's that debilitating 7 or 8 months of sitting on your hands pre-building permit to even be able to start the work. Therefore, the hardship having been established with regard to the conditions of the land, the secondary hardship—
You have 1 minute remaining.
Thank you. Not directly related to the— not directly related to money, but instead the time that is such a killer, is the basis by which we ask for this relief. And if the board will not consider our primary request for mere payment to the Cahal side, we would entertain and suggest that we are happy to take on board a middle ground alternate, which is payment to the sidewalk fund as calculated under the ordinance for all the frontages of this corner lot. Certainly I want to avail myself to any questions that the board members may have, as it seems I'm at the end of my time. Thank you always for your consideration.
Questions for Mr. Michael? I can't get I'm having computer difficulties. Remind me what planning recommended update the sidewalk, and is it, I thought it was Cahal. Are you saying Cahal?
Folks in District 7 are quick to correct us on that,
Okay.
Mr. Pepper. It's Cahal, apparently.
Okay, so Cahal.
Yes.
Okay, so
That was the recommendation from, and when we say planning, of course, we're really talking about the group that reviews those sidewalk waivers. Ultimately, a decision of the zoning administrator with heavy input from the engineers at NDOT, the folks at planning, and the engineers at Stormwater or Metro Water in general. Their recommendation was no build, no pay on Pennington, but construct the newly updated sidewalk 5 and 4 on Cahal.
okay, and so what if in lieu of us essentially voting a motion that is consistent with planning, you'd prefer to have your client just pay in lieu for the whole property because of is that what I understand?
The first preference would be to merely pay for Cahal because there is
Right.
no current obligation on Pennington. But if failing that, we would be willing to go the full Monty, if you will, and pay to the sidewalk fund for all frontages on this corner lot.
Okay.
Mr. Michael, in our packet, we have an email from February 25th from the council person. When did you last speak to her?
We swapped texts early this week, or rather emails this week, texts last week. So we've been engaged right up here to the 11th hour, it would seem.
Okay.
Can I get the picture where the telephone pole is on the other, Cahill? Cahal, whatever. Okay, so if you were to upgrade the sidewalk there, we have a problem with that. Okay.
The NES pole is an obvious problem. If you push in 4 feet, that's going to be smack dab in the middle.
That's
And
what I was
I
thinking.
try not to draw too much attention to that because it sounds like a pouty financial request. Additionally, though, if you look back just another click, there's also a fire hydrant right there at a good and appropriate and safe location that we'd also have to deal with. Hard to see from the aerial, but it is just up there. Perhaps, Mark, maybe not on the survey. Right at the property line, basically. So I'm confident that our sidewalk would also require dealing with the existing fire hydrant at that location.
Wow.
So, as I corrected you, Tom,
No.
unfortunately, I'm very familiar. I take this back way to Lytton and Gallatin Road to go back and forth if I don't want to take Gallatin.
Doesn't hurt my feelings to be corrected. Trust me.
And I will say that I can attest that this, and what Mr. Michael didn't tell you all is that street is like crazy narrow. It's almost really a one-way. I don't even know why they treat it like a two-way street because it's very, very narrow. So my only initial thought is I do think some sort of variance is warranted. I was going to lean into the expertise of our design professionals on how to exactly craft that. But just from my perspective, even where that ditch is, because of where it connects on that other corner, I think even building a sidewalk there might impact it, but I don't know. So I'm going to lean into Mr. Cole, Ms. Kaepernick, and Logan.
Does anybody have any more questions for Mr. Michael? So I'll close the public hearing and we can, okay, we'll close the public hearing and I think Ms. Davis was handing the baton to one of the design professionals. And there's one over here too.
I mean, yeah, I'm looking at, yeah, I mean, yes, the more you move it in, you do get into a much greater slope. You do have to affect stormwater. You do have to get the grading permit. I mean, everything he said is correct, and you do have to get that pole moved, which is quite an ordeal. Not to say that people don't do that kind of stuff every day, but it is a pretty big encumbrance to do that for someone building a house and on frankly a lot that seems pretty well suited to another structure. But
I mean, usually I would try to find some kind of middle ground, like maybe building a smaller grass strip but there, if you start moving in on the survey, you can see where it says 15-inch drain pipe. That concrete head wall, you can kind of see that in this aerial. So you're getting pretty close to that, and it's getting into the stormwater. If we even looked at some kind of, maybe a 2-foot grass strip or such. That's getting really close to the stormwater. What I'm interested in too, though, is just, and I'm a walker and I walk in my neighborhood and I think, gosh, I really wish Sylvan Park had more sidewalks, right? And I've probably been on cases where they got excused from building sidewalks in Sylvan Park. But, that edge of that roadway is pretty messy. And and maybe if it's okay, if I can ask the applicant, if you don't mind.
Sure. Does anybody object to opening the hearing back up?
Yeah.
Have at it.
Just from how I'm seeing it on this aerial, is there some way just to clean up that edge, like with the new build? I mean, are they going to be cleaning up that edge and making?
Do I understand the question to be the edge referring to the intersection where you make the turn on to Pennington?
Yeah, well, the edge along Pennington is not defined at all, and it's, is that something that, the applicant looks like they're going to do a new build, so are they going to take some care maybe to fix that up and make it more presentable?
Ultimately, they'll have to have the approval of the reviewing group at NDOT, formerly Public Works. So if the requirement is to reestablish that edge as you're describing it, absolutely. Even if not, we are happy to entertain that condition because we recognize it could only benefit. Often, and staff can correct me here if I'm phrasing this the wrong way, but as Mr. Hargis and I have discussed on other projects in the past, to clean up, fix up the existing sidewalk to the extent, for example, that construction equipment goes over and damages anything. Public Works, now NDOT, is not going to sign off until that sidewalk is corrected. Here, because you see the distinct absence of the bright yellow kind of grained strip that is helpful to those who have challenges with mobility, particularly those in wheelchairs. That's the odd kind of thing that's typically required on projects like this if you have to go in and build it anew. So those are the kinds of things I think my client would be eager to do for this project and would be happy to see that pinned as a condition if need be.
I think it's called the tactile warning strip, but I'm not the civil engineer, so.
And Ms. Kaepernick, when you say clean up that front edge, are you saying like a curb or?
Well, I don't think they could, I wish they could have a curb, but I'm thinking that's gonna fool with stormwater runoff, like stormwater coming onto the site and going into that ditch. I wish they could have a curb, but I was just hoping that they would clean it up, and if I mentioned it here, maybe they would do it.
Mr. Chairman, I'm so sorry to interrupt, but may I clarify something? I wanted to let the board know that there was something that I stated incorrectly in my initial presentation, and thankfully, Mr. Michael was kind enough not to necessarily rebut me, but he did correct the record, which I looked back at the planning recommendation. The planning recommendation is a full waiver along Pennington, not an in lieu fee.
So is this, along those lines, is Pennington, is that normally, or is she mentioned, I think you mentioned that it was a super narrow street. Is it normally required otherwise to have sidewalks, or is that not a required street in the first place?
Glad to jump on that grenade on behalf of staff. Yeah, it's required everywhere. If you're doing new construction, you're required. Now, the corner lot is a stated and contemplated basis under the Metro Zoning Code, particularly its updated 2019 version of the sidewalk ordinance found at 1720-120. The corner lot is a specifically sensitive area that the ordinance contemplates as being appropriate for consideration of relief via a waiver, or if the waiver result necessitates a trip to the BZA, then potentially a variance. But if you're building a new house and you found the strangest little lot in the world that had 4 street frontages, you'd be building 4 sidewalks theoretically.
Right.
Okay, so we started out with planning recommended actually that there be a full waiver along Pennington if they would build to the updated 2 code sidewalk along Cahal. And so what they're willing to do is they're asking for a variance along Cahal to not have to build, so essentially, right? And you'll fix up the 4-foot sidewalk, and then you're willing to pay in lieu for both Pennington and Cahal, correct? And you'd rather do that as opposed to having to bring the sidewalk on Cahal up to code?
Because of that time issue, yes,
time.
Mr. Chairman.
What do we think?
Is the public hearing, are we closed there now?
Yeah.
Okay.
Yeah, I'm sorry. I was seeking clarification. I assume no one would object.
I think it's very reasonable. I think that a reasonable thing would be to include with cleaning it up, to include the tactile warning strip that Ms. Kaepernick mentioned. And I mean, yeah, I think it might be a little bit undue hardship to require something more than the sidewalk variance noted itself being, because they did not require anything on Pennington, but I'd be open to hear others' thoughts on that. I mean, we all need more sidewalks, but.
So you're saying no pay in lieu of at all, but they fix up Cahal?
Yeah, and pay in lieu on Cahal and fix it up, but that's what I was thinking, but I'm interested to hear other thoughts.
I agree with you. I can't turn on my. Oh, there it is. I was say I agree with you.
Okay.
So I'm kind of there were a lot of people, especially when I first started serving on the BZA, that had to pay a lot of money in lieu of, and I always thought that, if the Metro Council didn't want it, they wouldn't have unanimously enacted. So, I would be for paying in lieu for both sides. I'm fine with them, not building up to code on Cahal. It would be great if they'd put in the tactile strip you're talking about for walking purposes.
I'm waiting on a motion.
So
Just a
am I.
second.
Well,
I agree with you, Mr.
We're
Pepper.
waiting to figure out where everybody.
I agree with you, Mr. Pepper. I like your approach. I like your approach that you suggested.
I like it too. The only reason I paused on it was that they've already been waived through a metro agency on Pennington. That's the only reason why I agreed with Mr. Newton, but I could agree with you too.
Yeah, and I gotta say, I was surprised by that. I really was. I remember there were a lot of corner lots where people came up in the past, and I know each case is different. There really is no precedent here, but it is, it's kind of fallen on a lot of other applicants in the past if they have a corner lot and they've had to pay. But Mr. Lawless has his light on, so I know.
Well, I mean, it's impossible, at least in my opinion, for them to do anything other than pay in on Cahal. Okay. So that's not a problem. I don't think, I'm not enamored necessarily with them having to pay in on Pennington. I'd like them to clean up the edge somehow. And the only reason I'm saying, not necessarily making them pay in, if they cleaned up the edge, they're going to spend probably as much as they would pay on the in lieu anyway if they do a good job. And I think I'm going to assume that they will do a very good job. And it may come as a shock to you, John Michael, that I would be so far in agreement with you, but still. And I just know you've got all those culverts around there, and just culverts in and of itself just seems to be a water backup magnet in this town nowadays.
So I will say, as someone who up until recently lived on a street with a drainage ditch in front of her front yard and all along the street, anytime new construction happened, it made it worse for everybody else's yard. The water would puddle. Despite all the things, the great things that the city does, when you have such an old way of dealing with water runoff, anytime you try to modernize it, it creates issues. So from my perspective, I would prefer them not to mess with the current. I want them to improve upon it, but it's always harder to do that. So I agree with Mr. Pepper, like in the spirit of fairness to everyone else who came before us before and had to pay for both sides on a corner lot, and now the Metro Council has created a remedy for that. I think, again, like, I'm not as smart as our design professionals, so I guess I want to craft a solution. I want to craft a solution that balances fairness to the process and also the fact that it may not be a great idea for them to mess with this drainage ditch. And so that's kind of where I am.
Well, I tell you what, I'll try a bit of a compromise motion here. How about they pay in lieu of on Pennington, but not on Cahal? That saves them some money. I think that's 56 feet of frontage.
Would you entertain a part of that motion to improve Cahal with a tactile warning strip?
Yes, I will make a motion that they pay in lieu of on Pennington. They don't have to pay in lieu of on Cahal, but that on Cahal they put at the intersection, I believe it is, they put the tactile strip that Ms. Carpenter talked about. So I'll make that motion.
I'll second.
Okay, we have a motion and a second. All in favor, say aye. All opposed? Okay. So that motion passes 5-1.
Thank you for your time, board members.
Okay, thank you. The next item on our agenda, we've got case 2022-29 was a consent motion. 2 items deferred, and then we move to case 2022-32, which is a request for a variance from the 3-foot side setback for property located at 85 Robertson Street, which is a non-conforming lot within the R6A zoning district. This appeal is brought under section 17.40.670 of the zoning code. I will pull up these slides.
Okay, is the applicant ready? Come on up, and if you would, be sure and do what I fail to do a lot, which is turn on the microphone with the red button there.
And I'll have to recuse myself.
Okay.
Conflict of interest.
If you would, please state your name, and you'll have 5 full minutes.
Sure. So my name is Brandon Mason. I am the owner of 2803 Blair LLC. Appreciate the time. This is pretty straightforward and simple. This lot is about 50 square foot shy of 5,000 square feet at 4,950. And it was brought up through the permitting process that any lot shy of 5,000 square feet, the first 25% of the structure has to be 3 feet off the setback within the first 25% of the property. But then it was offered by zoning or for us to go after a variance for this. We had already had our surveying plans done, we had purchased and done all of our architectural drawings, so we were pretty far down on the process, or we would have revised the documents. But it was suggested to us to apply for a variance, given that we were doing something that was similar to the area and not doing anything crazy with this lot. We're really just trying to build a single-family home within this neighborhood.
So am I saying it correctly that you're trying to increase the side setback rather than decrease it? Because it's a build 2 that's 3 foot. You're trying to build 5 foot from the side?
Yes.
Lot line? Okay.
Yes, Mr. Newton, this is a strange case, and it's almost an
Usually
inverse
the opposite.
variance.
Yeah.
You all haven't seen a case like this. We run into this frequently in these old grandfather lots in the old city of Nashville that are insufficient to the lot area in the zoning code. And our code allows you to do it, but says you have to do this thing. And so it was just an unusual case. I actually spoke with the applicant, suggested he file an appeal because
He actually called
We
me
don't
and
get
asked me the
these.
same question.
And so this is site plan that's up, that's where the structure will be built, this two-story single-family residence?
Yes.
Okay. And so you'd have a 5 foot setback on both sides?
Yes.
All right. Okay, anybody have any more questions for the applicant? If not, we'll close the public hearing and start discussing. Okay, we'll close the public hearing. It's, I don't know how,
You're trying to set the record, aren't you?
well, I think we said it a couple meetings ago when we got out too, so.
Yeah.
I mean, I don't see how, I mean, my thought, I'm not a design professional or an architect, or an engineer, but I don't know, I don't understand why the build 2, I've never seen a build 2 on a side setback, or if I have, I've forgotten it. So I don't know why any neighbor or the fire department, if there was a fire, would have a problem with increasing the distance between the homes, but others may,
I agree.
I mean,
y'all may see it a different way.
I agree.
I'm gonna make a motion. I've seen some nodding heads that we approve the variances requested due to the regular size of the lot.
Second.
Okay, there's a motion and a second. Any further discussion? All in favor? Okay, that passes 5-0. Thank you, sir.
Mr. Chairman, the case that was originally the case 2022-19, I was able to get a hold of the applicant. He's requesting, and I have no opposition to a deferral to April 7th.
Okay, and we would need to vote on that, correct?
Yes, sir, if you don't.
Okay. So 2229 has requested a deferral until April 7th.
Case 19, sorry.
Oh, case 19, correct, you're right, I'm sorry. Yeah, case 19 has requested a deferral until April 7th. Anybody want to discuss that? Do we? All in favor. Okay, Mr. Wallace has made a motion. Is there a second technically? Okay, all in favor? Okay, that's deferred until April 7th. Okay. See ya.
Okay, we'll go back to work.
Yeah, it's kind of hard at 2 o'clock not to do that, isn't it?
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.